If you co-own a property with your spouse, it will not automatically avoid the probate process and go directly down to your spouse when you pass away. It depends on how you hold title. There's one of two ways. It can be tenants in common or joint tenants with rights of survivorship. Tenants in common is the default way that they will structure title for properties. And so what happens is you will both say own 50-50 of that property. When one of you passes away, for the person who passes, your half of the house will have to go through the probate process. And when it goes through probate, it can do one of two things. If you have a will, your half of the property will be distributed per that will. Typically, it's going to be going to your surviving spouse, but it has to go through probate first. The other route is if you don't have a will, it will have to get distributed per the intestate laws of your state. So as an example, in Georgia, your assets will be split evenly between your kids and your surviving spouse, with your surviving spouse getting a minimum of 1/3 of your half of that house. And so your half of the house, when you pass away and it goes through intestate without a will get split up. It won't all go down to your surviving spouse. Now, if you hold it as joint tenants with rights of survivorship, your half of the house will automatically avoid the probate process when you pass away, as long as your surviving spouse just goes to the county clerk's office, files a survivorship affidavit and your death certificate. They will process those documents and make that transfer of that property, and it avoids probate altogether. So if you hold it as tenants in common, all you need to do is update it to be joint tenants with rights of survivorship, and then you'll be good to go. It will avoid the probate process and go directly down to your surviving spouse. If you want help setting this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.